professional. I am very happy to share various recent judgments with you, and today we are discussing a very recent judgment by Honorable Supreme Court of India decided on 9th January 2026. The name of the case is State of Uttar Pradesh versus Anurudh. This case is very vital because it talks about determination of age of the victim of POCSO cases. You know that POCSO Act in India was introduced on 14th November 2012, the day which is celebrated as Children's Day in India. Children's Day, that is 14th November, is the birthday of our late Prime Minister Nehru ji. So the primary requirement to invoke POCSO Act, my dear friend, is to establish that age of the victim is below 18. That means that victim of POCSO must be a minor. Another important point you must always remember that POCSO Act is asexual. What does it mean? That the victim may be either a girl or a boy also. Earlier in 376 IPC, the victim can be only female. However, if male was involved, 377 IPC was there. But now for the children, the gender is immaterial. Another important point for POCSO Act, my dear friend, the term rape has been removed because rape is a very dirty word. It has so much of social connotation, so much of social stigma. That is why the term rape is replaced by penetrative sexual assault. So having said that, in this case particularly, in state of UP versus Anurudh, the matter was like this, that the accused Anurudh went to High Court Allahabad for bail. So the bail application was filed, and how the matter was discussed is very interesting. In the bail application, the Honorable High Court Allahabad has discussed about determination of age of the victim, because when the age is about 14, 15, 16, so it is very difficult to identify whether the child or the victim is really minor or a major, because the difference is very, very weak or very, very blurred. So this is the case. Now let us start how the deliberation began, how it was deliberated, what were the findings. So age determination, as I mentioned the name of the case, again I repeat, State of Uttar Pradesh versus Anurudh, Supreme Court case decided on 9th January 2026. So age determination of a person to get minority status, this is the legal question. So purpose, why age determination is necessary? Let us understand that first. So age may be necessary to prove minority in Juvenile Justice Act. Juvenile Justice Act, my dear friend, was earlier enacted by our Indian Parliament in year 2000, and the rule were issued in JJ rules were issued in 2007. That will also come. But in 2015, the complete JJ Act 2000 was repealed and new set of JJ Act was rolled out, although it was implemented from 2016. So Juvenile Justice Care Act needs the age determination for the purpose of child in conflict with law. So the person who is delinquent, a child who may be delinquent, so the person, whether he or she is below 18 is a question, and that is why child in confrontation of law need to be decided the age. So that is first requirement. In the same JJ Act, the second category is orphan children, the abandoned children and surrendered children. So whether they are minor or not, because their treatment legally are different if they are minor or major. The third category under the JJ Act is adoption, adoption of child. So whether child is below 18 or he is a major, that is another conflict in the legal term. So JJ Act addresses these three categories. In POCSO also we need to determine age. As I said, that if you want to invoke POCSO Act, the duty of prosecution first is to establish age of the victim below 18. Because if age is above 18, then POCSO will not be in operation. So victim child must be below 18 years. And interestingly, section 27 of POCSO Act deals with medical examination of child victim or minor victim, but it does not give any clue or any guideline how age should be determined. That's the still existing problem. And I believe that whenever any POCSO Act amendment is in consideration, the proper mechanism for age determination must be introduced. Now, this issue immediately after the POCSO Act was brought in on 14th November 2012, the very next year, in 2013, a case was under discussion before Honorable Supreme Court. The title of the case is Jarnail Singh versus State of Haryana, 2013 Supreme Court. So this case actually laid down the issue before the court, and court said that there is no procedure for age determination in POCSO. So what solution the court suggested? The court gave direction that until and unless POCSO brought in their own mechanism of age determination, we have to borrow from JJ Act. Because in JJ Act 2000 at that point in time, the rule JJ Act rule, JJ rules 2007 were there. And in rule 2007, in rule 2007, rule number 12 subpart 3 deals with how age should be determined. So there are three categories, my dear friends. Rule 12 sub-rule 3 part A. It talk about that first you see the date of birth mentioned in matriculation certificate. If the minor or the victim is below 18, that is proved in the matriculation certificate, then first option is matriculation certificate. If matriculation certificate is not there, maybe a child may be 8 years, maybe 5 years, so how can she be completing matriculation? Or sometime the child could not get opportunity to do matriculation, hence matriculation is not necessary. In that case, if matriculation certificate is not there, then second option is the date of birth mentioned in the school records. Suppose she is studying in class 2, maybe class 4, or even if she has dropped out, the school records, that age will be second consideration. Then if this is also not there, there may be some possibility that child has never seen the face or the door of the school, then what? Then third is the record of municipality, the Gram Panchayat or the government official record. That is the third. The birth certificate given by a corporation, municipal authority or a village panchayat. So these are the three layers. First, give preference to matriculation certificate. Second, in case matriculation is not there, then go for school records. If not available, then go for village panchayat or corporation records. If all these three are not there, then only you can go for the another area 12 subsection 3, then subpart B. If 1, 2 and 3 are not available, then only you can go for medical examination, ossification test. But mind it, ossification test, a test conducted by a radiologist. Radiotherapist deal with the cancer therapy, okay, right? So radiologist, you go to radiologist for age determination by ossification test or any modern technology only when you do not have matriculation certificate or school record of age or village panchayat or corporation or municipal authority certification. So that is the point. And second point, you must know that the age gap, the ossification test is not a perfect test. It has plus minus 2 year, variation, possibility. Suppose a girl is of 17 years. So possibilities by ossification test, it may be ranging from 15 to 19 years. But once it crosses 18, the defense lawyer will say, oh, the girl is 19-year-old. So that is major. So this is a very, very problematic, and in these cases, medical test or ossification test may not be a better choice or may not be a perfect choice, rather to say. Then it again says, Rule 12 says that in case exact assessment of the age cannot be done, the court or the board, or as the case may be, the committee for the region to be recorded, if considered necessary, give benefit to the child or juvenile by considering her age on lower side within the margin of 1 year. Here it is important, this line is very critical, which is already mentioned in GJ Rule 2007. Now it is repealed. Now section 94 has been introduced. We will be talking very soon. But till that time, JJ Act 2000 was in operation. This was very prominent. So benefit of doubt of age will be considered in favor of the child, not in favor of the accused. And the advantage will be given for 1 year in case of medical test or whatsoever. Okay. Now, in JJ Act 2015, what is the status? What has been changed? So there is no major change. Only thing you remember in Rule 12. Now the age determination is directly taken into the Act itself. And what is the section? Section is 94. 94 of JJ Act 2015, which was implemented from 2016. So 94 section of JJ Act 2015 says, again, remember, the first and second, they have been integrated. Now they are in the one club. One club is that age mentioned in matriculation certificate or in school record. That is the first preference. If it is not there, then you have to go to municipal corporation record or village panchayat record. These are the number 2. If these 3 are not there, then only you can go for medical report. So I will read out the birth certificate from the school or matriculation or equivalent certificate from concerned examination board. In the absence of that, the birth certificate given by corporation or municipal corporation. And the third is only in absence of first and second above, age shall be determined by ossification test. So those 2 regarding the education side have been clubbed into one. The another was the Gram Panchayat or Municipal Corporation, that is 2. If these 2 are not there, then you have to go to third option under section 94 of JJ Act 2015 for ossification test by a radiologist. Okay. Here it is very interesting to note that age shall be determined by ossification test or any other latest medical age determination test conducted on the order of the committee or the board. So, in case police want to conduct age determination, they have to take permission from the board, Child Protection Board or the committee, not by their own. Provided such age determination test conducted on the order of the committee or the board shall be completed within 15 days from the date of such order. And if you have taken the order from the committee or board, the police must ensure that victim age determination must be concluded within 15 days, not beyond. Sometimes police sleep on the order, they may be busy here and there and they jump the 15 days line. So in case you jump 15 days line, then that ossification test report will be questioned. The important area here again, section 94 subsection 3. What does it say? The age recorded by committee or board to be the age of the person so brought before it for the purpose of this act be deemed to be the true age of that person. So that is considered true age of the person. Now, with this background, that was already decided by Honorable Supreme Court in 2013 that Jarnail Singh case, Jarnail Singh versus State of Haryana, that is the thumb rule of age determination for the victim of POCSO cases, right? But what happens in the High Court of Allahabad? Allahabad, as usual, Uttar Pradesh is a huge state, huge population, so cases were large in number. Because of various social issues, the Honorable Court thought that there are cases which are frivolous, which are concocted. The cases are being misused for meeting their personal end in the guise of POCSO offense. So that was the background. And in Aman versus Vans, Aman alias Vans versus State of UP into 2024. Prior to that, in Mone's case of UP 2023, the Honorable High Court referred several other judgments of Uttar Pradesh High Court and various other High Court, and with that the High Court in this Aman case, yes, it was concluded that the collective import of these judgments is that presumption of correctness attached to age-related document under section 94 of JJ Act is not absolute, it is rebuttable. That means that section 94 is not compulsorily to be adopted. It is not the ultimate source how you can determine age. Despite that, Supreme Court has decided it finally long back in 2013, and there is no contrary judgment by Honorable Supreme Court after Jarnail Singh. Further, the High Court is duty bound to obey the observation of Honorable Supreme Court until unless there is any legislative change in the law, right? So, having said that, court in Allahabad High Court, they take different route. And in Anurudh versus State of Uttar Pradesh, though it was a bail application, but Honorable High Court jumped to analyze the age of the child, or age of the minor victim. And it says, the question of law which arise for consideration in this bail application is the nature of the legal duty cast on the police to draw up a medical report determining the age of the victim while investigating POCSO Act. The jurisdiction of this court to determine this question will predicate the discussion on the merit of the bail. So, in short, if I say what was the observation of Honorable High Court in Anurudh versus State of Uttar Pradesh, when this bail application was discussed and decided, they said that the police is duty bound to produce the medical report for age determination. We are not going to stop by section 94 of JJ Act. So that was their observation. The Allahabad High Court doesn't stop here giving bail or to direct that medical examination for age determination must be conducted of the victim in case of POCSO cases. So it gave direction to the Director General of Police of Uttar Pradesh as well as the Director General of Health, saying that please ensure in every case of POCSO the age of the victim should be determined by ossification test conducted by a medico-legal expert. That means that it is the duty of the police to do that. Just I am reading out what were the directions. First, Director General of Police and Director General Health for compulsory medical examination. They will ensure it. These were the directions. In accordance with the provision under section 164 and section 27. So they say that 94 all alone is not necessary. We have to take it in the light of 164 CRPC, 164A CRPC rather. 164 CRPC says the medico-legal examination of victim of the rape irrespective of age, because 164 was much before POCSO Act was brought in. Okay. Medical report of the victim shall be produced before the court by the investigating officer before hearing of the bail. Now this is the nexus of putting medico-legal report for age determination along with the bail application to be heard by the Honorable High Court. That was a kind of compulsion, and it was the directives given by the Honorable Allahabad High Court to Police and Health Department. The court shall ensure that the compliance of these directions before hearing bail application. So now it is almost tagged that medical report for age determination must be compiled with the bail application. So whosoever will listen bail application of POCSO, the medical report for age determination is mandatory. That was the direction. Age determination must be determined by composite reading of section 94 of JJ Act, section 164A of CRPC and section 27 of POCSO Act. I think it made clear that 94 all alone will not stand in the eyes of our Honorable High Court as decided in this case. Now, observation of Honorable Supreme Court on 9th January 2026. The Supreme Court observed on medical test. In para 18, the observation was very clear. The importance of medical examination in harrowing crime of sexual assault cannot be overstated. That means there is importance of medical test, but it should not be overstated. It is not merely a record of injury or a catalogue of biological traces. It is a voice of the body speaking when words falter and memory trembles. So definitely medical report has its significance. Injury report and various other autopsy reports. So medical report cannot be defied, but not in every case. It cannot be a gospel truth for everything. Then Supreme Court kept observation on High Court directives on mandatory medical trial. So it is again in the same para 18. So the Honorable High Court keep observing the court could not have passed directions that go against clearly stated legislative intent under section 19 of JJ Act. So the Honorable Supreme Court said that look, already in Jarnail Singh case, it is a clear-cut verdict that 94 of JJ Act 2015, because earlier it was JJ Act 2000 under Rule 12, now it has been repealed, but JJ Act 2015 enter into the shoes of JJ Act 2000. So when it is already mentioned in that section 94, then the determination of the age of victim is a matter of trial, matter for trial. And the presumption which is accorded to the document enumerated under section has to be rebutted there, for that is the appropriate forum to do so, not the bail court. So they says that whether age is 18 or not, if there is any conflict, it is the duty of the trial court to look into it at the time of trial. It cannot be decided during the hearing of bail application. So this was the clear-cut observation. So the Honorable Supreme Court again reiterated that it is the section 94 of JJ Act 2015 which will solely determine the age of the victim of POCSO matter in case there is any dispute, and bail matter should not decided all these things including age determination. These are the two very clear message. So in para 20, the court further observed that these are the final observation. The appeal was allowed. The direction issued in the impugned judgment for mandatory medical tests were set aside. The observation of Supreme Court were extended to Aman and Mani's case. This is not Mani, it is Mani's case. The bail granted in terms of these judgments and order is left undisturbed. There were so many other cases referred, so they said that because we have not discussed merit of those cases, so we will not comment anything whether these directions will apply on that or not. But certainly because these two cases, Manish and Aman, were already discussed in detail, that is why these findings will apply to these two cases in addition to Anurudh case. The bail granted. So the special observation, yes, this is the food for thought to all of us, because you see now the system is changing. We are in the 21st century, and that too 1 quarter has been passed. Now we are living not only in age of AI, we are living in the age of artificial super intelligence. Now people are much faster. The children are not like 25 years back. They are much advanced. So their growth is also quite phenomenal, right? Mentally and physically. Hence we cannot think that they will be sexually active or they will go for romantic relationship only after 18. So we have to understand the social reality. Although there may be a school of thought contradicting this statement, but this is a stark reality whether you like it or not. So the Honorable Supreme Court has directed the Secretary of Law in Government of India to consider Romeo-Juliet clause. What is Romeo-Juliet clause? Although we will be discussing in the next session sometime soon, but I will explain a bit that Romeo-Juliet clause. You remember Romeo-Juliet was a very popular novel. Still everyone probably whosoever have some interest in literature, probably they have studied Romeo-Juliet. It was published in year 1596 by William Shakespeare. So in that, both Romeo and Juliet, they were adolescent, they were in love, they were in romantic relationship, and because the society did not accept their relationship, So they succumb to suicide. They finish themselves, right? But this case becomes very sensitive, and in US and many countries they have Romeo-Juliet clause, where the romantic relationship of adolescent are not treated as a crime, but that is exemption. However, there are certain conditions, and main condition is that the age between the girl and boy should not be more than 3 to 5 years. In country like US, there are 50 states, 26 states has Romeo-Juliet clause. Many other states around countries also has around 12, 13 countries have Romeo-Juliet clause. So Honorable Supreme Court suggested our law department in Government of India that just consider these kind of some exemption. So this is a suggestion, and I think the society should also consider, because otherwise a lot of killings, honor killings, rather it is called horror killings and other things, atrocities on these young lovers is very, very brutal. So now it is the society, it is the legal system, it is we and you all has to decide what should be the fate of our young ones, those are in such relationship. Having said that, thank you very much. And now before we conclude, let us just see what are our today's learning. Power of the High Court in bail application are limited and well defined. They should not transgress their limits. That is the direction of the Honorable High Court, Supreme Court in this matter. A determination POCSO victim solely by Section 94 of JJ Act 2015. Consideration for introducing Romeo-Juliet clause like US and other jurisdiction for accepting genuine romantic relationship among the adolescent young ones. So my dear friends, thank you very much for your kind consideration to listen me always, to give your love and affection, but I sincerely request that please subscribe our channel, distribute, share it with your friends, give your comments, whatever you have in your mind. You can suggest us if any improvement you have in your mind. If you can give us some topics, I will be happy to take up in the next sessions. This channel is for your empowerment, your upliftment, to make you legally teenable, more aware. Thank you very much. Bye. Good day.